You know 5-Hour Energy? You might have seen ads for it, some of which claim that this energy drink gives you a bigger boost of energy and focus than a cup of coffee. Another one tells the story of a guy who, after downing a 5-Hour Energy, disproves the theory of relativity, finds Bigfoot, swims the English Channel twice, and masters origami while setting a hacky sack record, all in 5 hours. Courts have determined that one of these claims is misleading enough that it violates marketing laws. This one, about the coffee. The ridiculous BS about the super productive guy is totally fine. That's because here in the US, companies are allowed to say things about their product that aren't true. In fact, the more blatantly false a claim is, the more likely it is to be legal. Order in the court! This is MinuteFood. Okay, don't get me wrong. Misrepresenting a product is against US law. That's why when the company that makes 5-Hour Energy got sued by the state of Washington, they had to present their evidence for the claim that 5-Hour Energy gives a bigger energy boost than a cup of coffee, which included literature reviews, controlled studies, and additional scientific research. But in the end, the courts didn't think the company had enough evidence to actually make the claim. They ruled it illegal, and the company was fined millions. But the other claim, the utterly ridiculous one about hacky sack records and Bigfoot and all that one doesn't require any proof at all to be legal. That's because it's a different type of marketing claim, known as puffery. Puffery first became a thing, at least a legally recognized one, back in the late 1800s. The Carbolic Smoke Ball Company in England sold smoke balls, basically rubber balls filled with carbolic acid, which you sniffed through a tube. The company claimed that doing so would prevent the flu, which at that point was a raging epidemic. If it didn't, their ad said, they would pay out £100, which was a lot of money back then. Spoiler alert, it didn't work, and the company refused to pay out. When they got sued, they argued that the offer was never meant to be taken seriously, that it was mere puff. The court acknowledged that, yeah, there is a place for obvious exaggeration in ads, although they didn't believe that that was what was going on here. So the company lost, but the case formalized the idea that some types of marketing claims are exempt from normal scrutiny, and it gave a name to these kinds of claims: puffery. Here in the US, the legal definition of puffery has been honed basically into 2 subtypes. Claims that are so wild that no reasonable person would believe them, like the 5-Hour Energy, origami, Bigfoot, English Channel one, and claims that are so vague or subjective that they couldn't actually be proven, like, say, a random diner claiming to sell the world's best coffee. Companies argue, and courts agree, that consumers should be able to recognize these claims as bragging for the sake of selling us stuff, rather than as actual factual claims about the product. That's why Snapple can say that their drinks are made from the best stuff on earth. Wheaties can claim to be the breakfast of champions. BMW can call their cars ultimate driving machines. And Hershey's can advertise a smile in every Hershey bar without having to actually back it up. The line between these different types of claims, though, can get pretty muddy. Back in the 90s, when a knockdown, drag-out pizza war was underway, Pizza Hut sued Papa John's for their claim, better ingredients, better pizza, which on its own is both vague and an opinion, the hallmarks of classic puffery. But the courts decided that, when taken with the rest of the Papa John's claims and ads, many of which directly referenced specific ingredients and specific competitors, that pizza purchasers might interpret it as a factual claim. So it did require evidence. There's just a really big gray area here between claims that are obvious puffery and super specific claims that consumers are likely to take as factual claims. The more specific a claim is, like mentioning or even just implying specific competitors, or specific attributes about the product, like its taste or effectiveness, the less likely it is to be considered puffery, and therefore the more likely it is to require evidence. But it's generally only when a claim is challenged by a competitor or a consumer or the government itself that companies actually need to show their work. So making a marketing claim is basically a question of risk management. How likely is a particular claim to provoke a lawsuit? If it does, how likely is it to be considered puffery versus a factual claim that does require evidence? And for a claim that might need evidence, what and how much evidence is enough? Because remember the 5-Hour Energy situation? There are reasonably high standards for what it takes to substantiate an ad claim. Like, if you were to make some claim about the taste of food, say that your yogurt has more berry flavor than a competitor's, you would likely have to survey hundreds of people in multiple regions of the country at a cost of hundreds of thousands of dollars to have a good shot at defending the claim. Claims about health, like that a supplement can boost your immune system, or that a drink can decrease arterial plaque by 30%, are even more heavily scrutinized, requiring an even greater investment. It's not like if you want to say that 4 out of 5 doctors recommend your product, you only have to ask 5 doctors. That would not fly. In that way, I do think the claim evaluation system we have here in the US does have consumers' best interests in mind. But the thing is, without doing a lot of digging, it's hard to know whether a particular claim has been evaluated or not. And because states have their own consumer protection laws and their own court systems, a claim might be evaluated over and over again in different places, sometimes with different results. Like, even though that claim about 5-hour energy giving a bigger boost than coffee was struck down in Washington, it's still up for debate in Oregon, where it's been stuck in legal limbo for years. So even though there is a system in place to protect us consumers from deceptive advertising, and as I learned during the course of making this video, there's some really smart and dedicated people working to execute and improve it, ad claims are just a really complicated issue. The bottom line is that you should still probably take most of what you see on TV, and really everywhere else, with a grain of salt, even when it comes to salt itself. As you might imagine, videos like this one aren't all that easy to put sponsorships on. Not many companies want to follow up a video on misleading ad claims with an ad. If you want to support our commitment to making awesome evidence-based videos that don't always please advertisers, head over to patreon.com/MinuteFood, where you can support MinuteFood and get all sorts of great perks. As always, a huge thanks to our patrons. You are absolutely the best. And that is a 100% factual claim.